They drove up. He got out of the car and went to my client's car and got in his car. The plan was once he was in the car, then these 8 police officers in 3 different vehicles would surround the car and make a bust. It didn't happen that way because once the confidential informant got in the car, my client, the defendant, started to leave. At that time, 3 vehicles converged on him with 8 different officers, and he attempted to leave that area being pinned in by these vehicles. In one vehicle was an Officer Thompson. He jumped out of the car he was in, ran in front of the car he was in, toward my client, and a collision took place between the 2 vehicles. It's a question as to whether or not the police vehicle hit him in the back first or the defendant's vehicle hit him in the front. But he was hit. But remember this, there was only one strike of the officer. At that time, he backed up and drove out of the parking lot, being followed by these vehicles. The state had that scenario, and they chose to indict him, and there were about 8 different counts. The first count was aggravated battery, that he did unlawfully cause bodily harm, knowing he was a police officer, by rendering a portion of his body useless by striking him with a vehicle. That was aggravated battery. And of course, that's an intentional crime. That is with malice. Aggravated battery.
Mr. Millikan, is your gravamen or your argument that the 2 crimes say the same person is the victim of both crimes?
Yes, sir, and one act. That's the most important thing, is one act.
And a singular victim of the...
Yes. There was only one officer, one striking, and one alleged act in all these counts. That is correct, and therefore...
The Court of Appeals found there were 2 acts, and that's why we granted the case. But didn't the Court of Appeals say that pointing the vehicle toward it was a separate act from the hitting?
They certainly did, but that wasn't in the indictment.
You're talking,
I don't know
you're talking about the
from.
way it's indicted. Also.
Exactly. Yeah, my point is, Judge Farley, that act, if alleged in the indictment as the reason for the assault, the Court of Appeals would be exactly right. But my client wasn't charged with any crime that had that particular fact in there, that is, directly steering the vehicle into the officer. They said that was the fact. It was never alleged, and it was never up to my client to disprove that, because it wasn't in the indictment. He had no notice he was going to be charged with doing that. In fact, if you read the indictment, they don't describe how the assault was being made. Nothing is said about it. And the case law, like I said, is very, very strict on this matter in showing if may have. If the jury may have convicted him of aggravated assault and serious injury by vehicle by his reckless driving, sorry, you have to throw him out and get a retrial. Because one is criminal negligence, one is intent. The jury found him not guilty of aggravated battery. Then they went to the aggravated assault. And they don't describe how the assault took place. They don't describe, like the Court of Appeals said, steering his vehicle into the office. Because that is his indictment. I'd take 1 minute to read the indictment as to what he's alleged of doing. To make an assault upon the person of Mark Thompson, knowing he was a police officer, that was the battery, okay? Dealing with the aggravated assault, the indictment alleged that he made an assault with a car that could be a deadly weapon. But it didn't describe how the assault took place or any act that took place. That's the aggravated assault. As to the serious injury by vehicle, They charged that by reversing the vehicle's direction of travel resulted in striking the officer. And they found him guilty of serious injury by vehicle. And they also found him guilty, he was charged with reckless driving, of reckless driving. And the reckless driving was defined not by driving toward the officer, as the Court of Appeals found justified the aggravated assault, but described it as being reversing his direction of travel. The same thing as serious injury by vehicle. So what do you do when you have a situation like this? The law is clear, and the cases I cite clearly show that mutual exclusion of verdicts prohibits a conviction of both offenses. And the logic is clear. Was it intentional? Well, they found him not guilty of aggravated battery, so he didn't intentionally strike him. But was it an intentional assault? We don't know. We know by finding him guilty of serious injury by vehicle and reckless driving, we know he was guilty of reckless driving. But reckless driving cannot cause an assault, particularly an A1 assault. That is, the assault statute lists two ways, and the first one is intentionally cause bodily harm to someone. And that's the way they were charged in an indictment, not by creating an apprehension of fear. That was never part of it. The indictment just said created an assault upon him. And they use this funny language that resulted in the officer being struck. So there's no act, no description of the assault that would permit the jury to find that he intentionally committed some act in the indictment that caused this officer injury. And the important thing is when you look at the indictment, and you can't find, Judge Parley, you can't find that separate act. I insist that this charge describes the situation in which you find yourself, and there's no way to get around it. That is, if there were two separate acts. Now, that's what the state's saying, and Judge Carley, that's what you said the Court of Appeals, based upon their decision, was a separate act. If there were two separate acts constituting two separate crimes that resulted in the vehicle striking the officer, the indictment should have specified the two acts. One, because it was so the defendant could defend himself against whether or not he committed that act in that way. Number two, whether the jury could know what's the act behind it. Let's find what the act behind it is and see if it's intentional. But when the indictment doesn't do that, it doesn't describe two different acts in two different ways and two different counts of the indictment to make it clear. Instead, we are left only with the reckless driving having resulted in striking of the officer. Now, that's been a requirement of the law for quite some time. You cannot be convicted of something that you're not charged with doing in an indictment. Isn't that the most unfair thing that could possibly exist? If I talked to my defendant now and I said, oh, well, the Court of Appeals ruled you directed your vehicle toward that officer. And he said, well, here's the indictment. It doesn't say anything in there about me doing that. They didn't mention that at trial. I couldn't defend myself against that at trial. I didn't know that was what I was charged with doing.